Hello, my name is Jay Gadjar of LondonLawTutor.com. This is a sample of a series of lectures available and to be expected across our YouTube channel. Our YouTube lectures range from various subjects. Currently available, we have some material on equity and trusts, constitutional and company law. This lecture will concentrate on employment law. We're going to skip ahead from the sources of employment law, which briefly originate from international and domestic legislation. We will today instead be looking at who or what constitutes an employee. This is not an academic or abstract exercise that complies the minds of academics across universities, but instead, in many areas, the law treats employees very differently from other workers, such as self-employed contractors and other parties. For example, if a claimant is trying to prove that they have been unfairly dismissed, they will first have to prove that they are an employee in order to enjoy the protections that are afforded and relate to unfair dismissal. As with most things, the first point of call is statute. Section 230, subsection 1 of the Employment Rights Act states that an employee means an individual who has entered into and works under a contract of employment. The statute is not very helpful. But sometimes definitions need to be sufficiently vague or ambiguous to cater for unanticipated cultural, economic and societal shifts. That will happen over time with regards to the employee relationship. In light of the vague statutory definition, and given that contracts will not always expressly stipulate whether they are contracts for employment or services, and given that form that is put on a contract of calling it a contract of employment or a contract of services is not necessarily going to be taken on by the courts themselves have catered for certain definitions. As a brief example of the changing nature of employment law and the relationship of employers and employees, we now see that women go to work, with more men staying at home, and more calls for equality between women and men. The first test comes from Ewan and Noakes, a case in 1880. The test of employment here is broadly known as the control test that was formulated by Lord Justice Bramwell. He stated that a servant is subject to the commands of his master as to the manner in which he shall do his work. In other words, the master or his employer will dictate how it is that the employee will carry out his work. This test was sufficient for the time when employment broadly ranged from manufacturing and agriculture. A test from the 1880s is hardly appropriate today. The level of inappropriateness can be seen if applied to modern-day situations. Take, for example, the case of Walker and Crystal Palace of 1910, where an injured football player wanted to be found as an employee for the sake of bringing an action relating to his injury against his employer. Applying the Ewan and Noakes control test is hardly going to be satisfactory. It can hardly be said that he was subject to the commands of his master as to the manner in which he did his work when he was on a noisy football pitch with little communication. There the court instead implied a control of background arrangements test to find that he was an employee. The control of background arrangements looked at the fact that his employer was in control of what time the footballer came to work and what hours he played, and there was also a stipulation that he was not allowed to live above a public house due to the nature of his job. Similarly, applying the Ewan and Noakes test can be seen as inappropriate in the case of Cassidy and the Ministry of Health, a slightly later case in 1951 involving a brain surgeon. Here the employer will not control the surgeon in the manner of his operations and how he conducts them. It is the employee, or the surgeon, so to speak, who brings the expertise. These cases are a clear indication that the test in Ewan and Noakes, the control test formulated by Lord Justice Bramwell, has not withstood the test of time. The nature of employment had changed, and so there was a need to change the test that defined employment. This job of development fell on the judiciary. In the case of Stevenson, Jordan and Harrison Limited and MacDonald and Evans, 1952, Lord Denning said that a contract of employment was one where the person was part of the business as an integrated entity, whereas a contract for services lacked such integration even though the work was done for the company. Following this came the economic reality test that was seen in the case of Market Investigations Limited and the Minister of Social Security in 1969, where in the High Court Mr. Justice Cook thought that there needed to be an escape from the single test or the single factor test that had been seen in previous cases, and instead that cases should weigh up various economic reality factors to come to a decision. Amongst these factors included whether the employee provided their own tools, whether they provided a personal service, and how far the employee profited from their good work, along with the responsibilities of investment and management. The case has been regarded by many as being incredibly authoritative and is still used in courts today. However, the list of factors given are not exhaustive, and it is up to the court to weigh up the various factors and come to a decision as to whether a worker is an employee or a self-employed contractor. Flowing from this, additional factors have been added in cases such as Nethermere and Taverner and Gardiner in 1984. In this case came the mutuality of obligations test, where the question that had to be asked was whether there was a mutuality of obligations for both the employer to offer work and the employee to accept it. Clearly, this brief introduction to the case law surrounding the definition of an employment contract or a contract for services is indicative that there is good reason for the Employment Rights Act 1996 to leave the definition of employment as vague and as wide as possible to cater for the social, economic and cultural changes that will have a wide impact on the nature of employment. This concludes our brief podcast on the cases surrounding the nature of employment contracts and the definition. Please stay tuned and continue to log into our YouTube channel for further podcasts in a very short time. Thank you.